In this lecture, we are going to discuss intellectual property and model and data licensing. We will start by defining what intellectual property is. We will look at the terms derivative work and fair use. We will go through a few outstanding legal questions that are working their way through the courts right now. We will look at who can be an inventor on a patent application. We will then do a short round of buzzword bingo, where we will identify some terminology that you need to know in order to be aware of challenges concerning AI and IP. We will then conclude with a note on how data and model licensing works and infringement indemnification. So what is intellectual property, or IP? Intellectual property, in short, consists of intangible assets. These can include inventions, brands, new technology, and source code. There are three categories of intellectual property that you need to be familiar with. These are patents, trademarks, and copyright. A patent gives an individual a time-limited protection for their invention. This provides them with the exclusive right to make, use, or sell something, such as an item or a piece of software, new technology, for example. Trademarks apply to logos, slogans, and brand names. And a copyright protects a technology, in our case here of artificial intelligence, such as the data or code, from unauthorized use or reproduction. When it comes to understanding the intersection between artificial intelligence and intellectual property, there are a few terms that we need to understand, as you'll see when we get to some use cases later on. One of those terms is derivative work. A derivative work is an expressive creation of an underlying work. The derivative work then becomes a second separate work. In order to qualify as a derivative work, the changes made to the work must be substantial and show the author's personality. Examples of derivative works include translations, cinematic adaptations, and musical arrangements. Another concept that you need to be familiar with is fair use. This allows an individual or organization to use copyrighted works without the author's permission. Examples of fair use include criticism, satire, comment, reporting, teaching, scholarship, and research. There are a few outstanding legal questions that you need to know about for the exam. And just to be clear, outstanding legal question means these are issues that the law has not directly addressed. And through a number of suits, these questions are working their way through the courts. The questions that you need to know for the exam are: how do existing intellectual property laws, principles, and protections apply to AI outputs? Are these outputs considered original? And if so, how does copyright apply? Can AI be named as an author or innovator on a patent application? And if not, to what degree must a human be involved in the production of a work or output or innovation for the work to be patentable or copyrighted? On one of those questions, who can be an inventor, we do have a couple rulings from courts to help us answer that question. One in the United States context and another in the European Union. In the United States, a case that you need to know is Thaler v. Vidal, and this is from 2023. In this case, a U.S. Court of Appeals ruled that only humans can be named as inventors on a patent. In the European Union, the European Patent Office in 2020 refused 2 patent applications naming AI as an inventor. And so as of right now, it looks like AI cannot be named an inventor, but of course, this is a space that you'll want to keep an eye on. For the remainder of the lecture, there are a few terms and concepts that you need to be familiar with. For the rest of this lecture, we're going to be talking about data and model licensing. And so we need to know what licensing is, as well as, again, just for clarity, who is the licensor, who is the licensee. So licensing is official permission to do, use, or own something. And so I have a new technology, and instead of me producing that myself, I'm going to license that technology to another organization and give them permission to use this technology for, I don't know, let's just say 5 years. They use it for 5 years, and then there's an opportunity to renew the license, or I can decide not to renew that license. Here, a licensor is the individual or organization that is giving permission, and the licensee is the person receiving permission, again, to do, use, or own the technology in this case. Data licensing, therefore, is a license to use data. For example, a website may license their data to an AI company, giving that AI company the freedom to use to scrape that data and to train their models on that data. Similarly, model licensing is the license of a model. And a final term here that you need to know is indemnification. This is the contractual obligation by one party to pay for a loss incurred by another. And this may come up in the context of intellectual property, as we'll see later. With regards to artificial intelligence and intellectual property, there are a number of challenges that you need to know about. One is determining a data owner. And so, for example, if information, perhaps personal information, has been posted on the internet, if it is publicly available, who owns that scraped data? Similarly, regarding inputs and outputs, who owns that? Is it the person who created the prompt? What about the output? Does the model, does the algorithm, the AI own the output? Does the company, etc.? Similarly, accounting for licensors' ownership of data and licensees' permitted use of data. What happens when training data might include unlicensed works? What happens if a model creates an unauthorized derivative work not covered by fair use? Finally, what happens when PII and confidential trade secrets are input into a model and become part of the model? Is there any recourse or any way to retrieve or remove that information from the model? So how does data or model licensing work? And this might have been self-explanatory when we were doing the buzzword bingo a moment ago, but again, really just to make sure that we understand how this process works. And so an organization will designate AI components as confidential information. The organization then limits the rights to use those components and that confidential information. This includes assignment rights in model evolutions from one party to another, and may include liability and indemnification. Remember that you have a model, but the model is going to change and evolve as it starts receiving inputs and creating outputs. And so if I have one identical model, I copy that 3 times, I give it to 3 different organizations. Those organizations, perhaps they do some fine-tuning, perhaps they put that model in 3 relatively different environments. The model is going to respond and change in different ways. And so ultimately, who is responsible for any of the risk? Who is liable for perhaps any intellectual property infringements that take place? These are all issues that are being worked out. You don't need to know about these licensing deals for the AIGP exam, but I just wanted to point out in May 2024 alone, OpenAI locked up 4 deals with massive repositories of historical and constantly refreshing data. Stack Overflow, Reddit, Vox and The Atlantic, and News Corp, which includes the Wall Street Journal, the New York Post, and more. OpenAI has licensed the data on these websites so that it can continue legally to scrape the data and incorporate that into future models. Our final note here is on infringement indemnification. Now, there are a number of cases where if an organization is indemnifying another, that clause may be voided under certain circumstances. Exceptions to traditional software and technology licensing have voided indemnification protection when that software is modified, when there is an unauthorized combination of that software with another software or technology, or when that software, that system, is being used beyond its authorized scope and beyond the agreement between those organizations. For example, if I license you a model or I license you data, and it turns out that you're doing something I asked you not to do with that model or data, then that may void the indemnification, meaning that if there's some liability there, your organization is now taking on that liability. In this lecture, we have looked at the intersection of intellectual property and artificial intelligence. Remember that intellectual property includes intangible assets, such as inventions, brands, new technology, and source code. The three major categories that you need to know about are patents, trademarks, and copyrights. You also need to know what a derivative work is. This is an expressive creation of an underlying work that becomes a second separate work. You also need to know about fair use. This allows copyrighted works to be used without an author's permission. Outstanding legal questions that you need to know about. How do existing intellectual property laws, principles, and protections apply to AI outputs? Are these outputs considered original? And if so, does copyright apply? Can AI be named an author or an innovator? And if not, to what degree must a human be involved for the work to be patentable or copyrighted? Two cases that you need to know about concerning that inventor question. These are Thaler v. Vidal in 2023, where U.S. District Court ruled that an AI cannot be listed as an inventor, it can only be a human. And similarly, the European Patent Office in 2020 denied two instances where AI was named as an inventor. Terms that you need to know include licensing, licensor, licensee, data licensing, model licensing, and indemnification. Some current challenges that we discussed include determining data owner, accounting for licensor's ownership of data, accounting for licensee's permitted use of data. Remember, with regards to how data and model licensing works, an organization will designate AI components as confidential information. They will then limit rights to use those components and confidential information. This includes assignment rights in model evolutions from one party to another, and can include liability and indemnification. Finally, in some cases, infringement indemnification may be voided if there are modifications to the software, if there's an unauthorized combination of the licensed software or data with another software or piece of technology, or if that software is used beyond authorized scope or the terms of agreement.